All right, I think we can go ahead and get started. I see that we still have some participants being entered into the room, so I was watching the number count to make sure that we had everyone. So welcome everybody as you get into the Zoom. This is the GDPR compliant Now What Else Are You Missing presentation from Baker Hostetler in the US and the Fisher law firm in Switzerland. So we're going to cover a bit of Swiss law, a bit of US law, both today, and I've got a lot of material to get through. This is being offered for CLE credit, so if you need CLE credit, you will be offered a survey at the end of the program. In that survey, you're going to need to enter 2 codes. The codes will be given to you during the presentation, so just make sure that you take note of those. And that is the key thing with the CLE credit. You'll need to note which state as well, I believe, for that. Other than that, if you want to put questions into the Q&A section in Zoom, we can take questions from you. If we don't get to them today during the presentation, we are also happy to follow up. So I'm Nicole Sterling. I'm a partner in the New York office at Baker Hostetler. I'm a member of our privacy governance and technology transactions team within our digital assets and data management practice group. And I'm going to hand it to Melinda to introduce herself.
Hello, I'm Melinda McClellan. I'm also a partner in the New York office of Baker Hostetler and co-lead of the privacy governance and tech transactions team. We have our colleague Joyce on the line as well. Joyce, you want to introduce yourself? You're on mute.
Hi, I'm Joyce Ackerbaum-Cox. I'm a partner in the Orlando office of Baker Hostetler, and I practice in the area of labor and employment law.
Good, and I am from the Swiss side, on the other side of the Atlantic. I'm David Rosenthal. I'm the head of data and privacy and investigations and e-discovery here at Fisher, a business law firm in Switzerland. Switzerland is very small, but we still have 3 offices over here. And I will also do the first section. We already have a question. Will we be able to access the recording later? Yes, it will be on the website of Baker Hostetler, available to you, the recording. That is okay, then Nicole, I will take over and jump into the first part where we will talk about what else are you missing on the the Swiss Data Protection Act. The Swiss Data Protection Act is new. We have it already for a long time, but it was now revised on September 1st, 2023. Finally, more than 5 years after the GDPR. And basically what we have been doing is we have been following up on the GDPR. So we already had before that a very comparable data protection law in Switzerland as in the rest of Europe, you would say, or the European Economic Area, the EU, and some other countries. And what we've been doing in the last 5 years is discussing on how we could make it maybe better or more Swiss style. And we have come up with our own version of, let's say, the GDPR, which is much more principle-based and is much more lean, which has always been a tradition of Swiss law, but in substance is more or less the same. So you have basically the same basic principles, you have the same type of things like records of processing activities for those of you who know GDPR, data protection impact assessments, data processing agreements, and international transfer regulations. So we all have basically the same concepts here in Switzerland. And you could ask yourself, what else are you missing? We do have, however, something that we refer to as the Swiss finish. And there are positive and negative Swiss finishes. There are some things that are leaner and, let's say it from my view at least, better in Switzerland, where we're less complicated. For example, on privacy notices in the GDPR, you have a huge list of things you have to put in the privacy notice. And under Swiss law, it's much leaner, although we also have, and I will be talking about that right in a moment, some additional requirements. But in general, if you have processing activities that are fine for the GDPR, then they are in principle also okay for Switzerland. So you don't need to change what you have been doing in terms of how you process personal data. We even had in the new law a change where we have given up what we long had, which is a protection of data of legal entities. So in Switzerland, for the past 30 years, we basically had a protection, data protection also for data of legal entities. That has been gone. That's now no longer the case. But, and that's the reason why we're actually sitting here, we do have a number of pieces in Swiss law which you should know because they are stricter and they can get you also into trouble. And at least that's what we hear also from our clients. Some are very concerned about them. And I want to let you know where we have that Swiss finish with regard to things that are stricter or different. And here you have them, at least the first part of it, 6 you see now here, and those are the points that when you have an organization that is GDPR compliant and bracket opened, I don't think that anyone is really GDPR compliant because you can't be it fully compliant. And that's the same thing in Switzerland. But if you have a compliance program for the GDPR, then there are a few things that you should check and see whether you actually cover that or not. The first thing is more something that is a bit more in a basic part. It's actually the reach of Swiss law. Under GDPR, you know, it has an extraterritorial effect. If you target people in the EEA or if you track them in the EEA, then it can become subject to the GDPR. Under Swiss law, it's actually much broader. If you have personal data of somebody being in Switzerland, even if it's not targeted, what you do to Switzerland, you already are subject to Swiss data protection law. So basically, we have a law that is much broader, effective. The other question is, do people really care if something's not okay in Switzerland and are sitting in the US, for example? What is the practical reach? I have to leave that a bit to you, but we do have, and we already had for a long period of time, a much broader reach. We also have now provisions that say if there is an effect in Switzerland, that even if you have a service provided from outside, you will still be subject to Swiss law. We have been representing Google a long time ago, or I have been at my former firm with their Street View case, with their Street View service, which had an effect on Switzerland because it showed streets in Switzerland and it was subject to Swiss law, even though it was not offered out of Switzerland, was offered out of the US. That doesn't make really a difference. Now, once you are in Swiss law, there are some other points you should look at. I told you before that the privacy notices can be much shorter under Swiss law, and actually I've drafted a template for a privacy notice for small companies that fits on one single page, and it is compliant in my view. But we have one big difference. We have additional language required on top of what you have in the standard privacy notices. In Switzerland, we have a provision in the law that basically says you need to list all the countries to which you may export personal data, and you also need to list the exemptions you rely on. So the Article 49 of the GDPR exemptions, which means you have to amend your notices. You don't have to list essentially every country. Most people come and say, we export data potentially in any country of the world, and that's fine as well. That's at least what we and the major view believe is happening and what is okay, but you need to take care, so there have to be some amendments. We have different rules on how you can push back on access requests, and there are some pitfalls. For example, if you share data with others outside your group of companies, you cannot rely on your own business confidentiality protection. So you cannot rely on your own interests. So make sure that if you have sensitive information you don't want to share in case of an access request, that you are sufficiently protected. Otherwise, you will have to disclose it, and that may be not very fortunate. We have a difference also in data breach notifications. Actually, for my US colleagues, this is something you invented, the data breach notifications, long ago. Finally, we also have them in Europe. The GDPR brought them. We had them in some countries before, and now finally we also have them in Switzerland, but we have them differently. So in the GDPR, you have to go to the authority when you have a risk. So the prime place to notify is the authority. In Switzerland, it's different. In Switzerland, the authority doesn't want to hear about your notifications, except if it's really a high risk and they're making life difficult so that you can't easily notify them unless it's really a serious case. But in Switzerland, we have to notify the individuals if you have anything that could help them to protect them. So there may be cases you don't have to go to the authority, but to the individuals. On international transfers, it's essentially the same as in the EU, but we have fewer adequacy decisions. So Japan and South Korea is not on the list. The US, by the way, at the moment also not, will follow shortly with the data privacy framework. And if you use the EU SEC, you need specific Swiss amendments, often gets forgotten. And finally, we have a professional secrecy obligation in our law, which is something that's very unique in Switzerland. That's not the case under the GDPR. We basically have professional secrecy, not only for Swiss banks, you know, about Swiss banking secrecy, or MDs or attorneys. We have it also now for everyone. And it's under a criminal fine if you disclose professional, the secrecies, data, personal data that was entrusted to you, even if you're not in a regulated industry. And that can lead to a criminal fine of up to 250,000 Swiss francs, which is about $270K dollars, if you breach that intentionally. And we do have, and that's now the point, criminal fines also for a number of other provisions. You see them on the right side, the aspects that are subject to fines. Unlike the GDPR, we do not have administrative fines against the company. In Switzerland, the decision was made to go after the individuals who basically not comply, or, and that's particularly interesting and worrisome for some companies, to the management, up to the board, if they don't take the necessary steps to basically prevent these things of happening. For example, to have a privacy notice that is not correct and complete, and that is usually always the case, or to not be in line with international transfer regulations, or, for example, processor agreements. The interesting thing is some other parts, for example, the data breach notifications is not subject to these fines, but you can imagine that most managers, they don't like being on the hot seat because you cannot insure that, and the company is not allowed to pay it, so you have to pay it out of your own pocket, and that's something that people don't really like. Although I believe it won't be very often because it's not the Data Protection Authority that has basically control of this. This is with the state prosecutor. I've actually written a piece that you may be interested in reading in a bit more time, which is on the strategies, how you can avoid being fined. And there is, in a nutshell, basically two things you can do as a DPO or as the person who's responsible for data protection. Make sure you have no decision power. So just advise, not decide, and not sanction in the sense that they have to come to you and get your approval. Make sure you don't have that anywhere. And if you can't approve or can't stop something, you can just tell somebody it's not okay, then you're more or less safe with regard to decisions. And on the management side, make sure you have a proper reporting to you, because what we see most is that companies do have instructions. Management tells you, take care of this, but they do it in a fire and forget manner, and they don't go and follow up on that, have a proper reporting on how to find out what's going on in your organization. And those are the key pieces of advice. They are in there explained in detail, and I'm of course happy to answer your questions. I also have you here some materials, and then I'm already at the end on my side, that may make your life easier. In the middle, you see a comparison between the GDPR and Swiss law with all and more what I've just told you. On the right side, you see, and that's fortunately possible in Switzerland, all the Swiss Data Protection Act on one single page. And if you do all that, then you're essentially fine. And I'm not sure whether that would be possible for the GDPR, but in Switzerland, that works. And on the left side, you see a service that we've created, which is for free, and you can even use it anonymous. You won't get even marketing mails from our side, where you can do a fully fledged assessment, whether you're compliant with Swiss law or the GDPR, have cloud projects assessed, and you will get these kind of PDF reports like you see on the left side, including an assessment of what your exposure is from a criminal law point of view. And you can also use that basically as a reporting tool for management, or management can go and ask, please complete that. And then they have a bit better view and understanding, and that's for free under the address you see, which is the end of my presentation. And if there are any immediate questions, I'm happy to answer them. Now, there we say, does Swiss law have a view why a legal basis is not required under Swiss law? Yes, this is a big difference to the GDPR. We don't have an Article 6 GDPR. We don't need a legal basis. We have a different concept in Switzerland. In Switzerland, we always had the concept that you can process data. It's principally allowed as long as you comply with the basic principles, which are like GDPR Article 5. And if you do not comply with them, so if you want to use something for a different purpose or intransparent, for example, in an investigation, you then need a legal ground to justify. So we have a different concept, but in practice, it works. And we don't have a lower level of data protection, but it makes life hell of a lot easier because you don't have always to go and find out, is there consent or is there a contractual requirement? You can just process data, and that is a tradition in Switzerland. We always had that, and we fortunately didn't give it up because that's one of the biggest issues under the GDPR. Okay, any other questions? Yes, on the access request pushback. Exactly. I told you that there are ways on how you can push back. They are similar as under the GDPR. We can go and say if somebody, and that's actually even was added very late in the deliberations in Parliament, is that if someone requests data for a purpose other than data protection law, you can push back on that. That's maybe a bit better than under the GDPR, but you can only rely on overriding own interests, such as internal decision-making or business secrets, if you do not share your data with somebody outside the group of companies that you are. So the moment you have data that you share with authorities on a regular basis or other controllers, so to speak, you can no longer rely on an overriding private interest to basically push back on an access request. And under the GDPR, that's something you can do. You can come and say, if we provide access to the data, then we basically have a situation where our rights would be infringed. And in the moment you share data with others, then you have that type of an issue. You, of course, still can go and argue that it's, if you were to give access to data, you would violate third-party rights or so. That is still possible, but you can no longer rely on your own overriding interests. We have discussed this. We wanted to have this out of the law because it's really nonsense, but it stayed in there, and it can become a problem. So in some cases, you may not want to share data with others to make sure that it's not open to access requests.
David, I had just a really quick question. Have we seen anyone actually get fined under that 250,000? Has anyone actually been fined yet?
No, not yet. I've heard of some, because I mean, it's rather new. It has just been introduced. And in Switzerland, things are slow. So that will take time. Maybe in a few months, we hear something. I do have heard of one colleague who told me they already got a complaint. And where we would expect this to happen is where you have disgruntled employees or people who want to basically harm you. It's not the data protection authority that can issue a complaint. It must be a data subject. But you have, of course, an exposure. And one of the reasons why everybody jumped on creating their privacy notices was because that's something everybody sees. And if you put in things, and that's what we've started to do, for example, things into the privacy notice that are not necessary, you expose yourself. For example, we have started taking out of our privacy notices language on how long you have to store data, because usually the language in the privacy notice and how long you have to store data are not complied with. So rather take it out because you don't need it under Swiss law, or put it in the section that's just for the GDPR. And with that, do not expose yourself that somebody comes and says, but you have incorrect information. You have stored data longer than we have. And if you want to find something that's not okay, just look at a privacy notice and you will always find something.
That's a good tip, and it kind of leads into us talking about US issues, as we have to thread the needle of things that are required in notices under US law and the EU and GDPR, and obviously Swiss law and then other jurisdictions. So
yeah, we do have a couple other questions that just popped up, but we can hit those at the end, I think, if we have some time.
Good.
So
over to you.
So just to pause briefly here, this is your first CLE code. It is consumer. So you can see that at the top, and we're going to head into this section on, so you're GDPR compliant, but the United States is going to make everything more complicated. So again, that CLE code is consumer. So Melinda,
Yes.
do you want to tell us about this slide?
So we've always had the alphabet soup or the patchwork quilt, or however you want to characterize it in the US, of some federal laws and certain state laws that not one comprehensive law to comply with as the GDPR kind of serves up for you. And it's just gotten worse. It's gotten very much worse the past few years. So this map is illustrating in yellow the states that have passed and enacted the state comprehensive privacy laws, somewhat modeled after the GDPR, but obviously with their own twists. The ones in dark blue are the ones that pass a law that is coming into effect in the next, I guess, year. On the list over here, year and a half or so. And then the light blue ones are, let's say, yet to come. And then over on the side, we've talked a bit about we've just listed some of the laws that we also have to consider. So you may be GDPR compliant, but which of these other regimes may apply to you? There tend to be sector specific. Obviously, some of them are state specific. And this is not at all an exhaustive list. It's just a few.
Yeah, these are probably the ones we run into most frequently at the moment. And so the list that you see under the other parts of the US alphabet soup is sort of roughly divided by federal and state laws. And so one of the things to keep in mind as well with the US privacy laws, if you're dealing primarily with the GDPR, coming over and dealing with something here, you can end up with being under multiple federal laws and multiple state laws all at the same time. So there are lots of ways that all of these laws, I'm looking at them now. I'm like, I think it is almost possible for you to be subject to every law on this list.
Yes, you could conceivably be subject to all of them. And some of the state law, most of the state laws have some exemptions if you are already complying with the federal law, at least with respect to the data, for example, under Gramm-Leach Bliley or under HIPAA. That information in that context isn't covered by the state comprehensive law if you're complying with the other federal law. So it creates quite a mess, especially when you bring in employee data into the mix, which isn't necessarily under those. And part of the reason that we listed some of these, like the TCPA, the VPPA, Illinois, are because these are areas where we see a lot of class action litigation, where there is a private right of action, or the plaintiffs' bars developed their own concept of a private right of action, and is bringing suits that are related to privacy interests that may not have existed when the law came into effect. For example, the Video Privacy Protection Act, which was passed at a time when everyone still went to Blockbuster Video and rented tapes, and it's meant to protect the privacy of your rental history. Well, and now it's being applied to, do you have videos on your website? And do you have cookies or pixels on your website that may be transmitting information about viewing of those videos that's occurring on your site? If so, there are lawyers that say that you might be violating the Video Privacy Protection Act by disclosing the video viewing history of your website visitors to, say, Facebook or another pixel or cookie provider. And the TCPA, obviously, with alleged text message consent violations and opt-out problems, that there's a lot of litigation on that. And then biometric privacy. There are many states that have some type of biometric privacy law. Illinois has the one that has inspired the most litigation because of the private right of action, but there are other states that have notice and consent requirements just for biometric information. And there's some states and localities that have enacted restrictions on using facial recognition technology specifically. So whereas in under the GDPR in Europe, that's a type of a special category of personal data that is regulated as such. Here, it depends on what you're using and in which state you're using it and how you're using it as to whether you have to give notice about it and or get consent to collect it. I'm speaking specifically about biometrics, but it just illustrates some of the complexity of complying with all the different types of privacy laws in the United States.
And I think the other thing to sort of point out on that is that the states are a little bit different in how so Melinda had mentioned briefly that certain of the federal laws can have exemptions from various pieces of state law. The states have applied that differently too. Sometimes it is an entity level exemption. So if, for instance, you are subject to something like GLBA or HIPAA, your entire entity may be out from under the scope of the state law. Other states do it on a data level exemption. So that means that any data that you have that would be subject to GLBA would be out from under the scope, but everything else that you have would not be. So that also creates complexities, and especially for the types of companies that might be working in a state that has these data level exemptions and have some exemptions under HIPAA, some under GLBA, some under other things, and to figure out ways to divide and understand how all those data flows work has been a particular problem, I think, for a lot of companies dealing with the US laws.
First, identifying what data you have and then determining which legal regime it falls under and whether or not it qualifies for the exemption, depending on how you got it and the nature of your relationship with the person whose personal information it is. It just isn't straightforward in a lot of cases.
So, and yeah, so we can see we still have Utah coming into effect yet this year, a bunch next year, and there are a bunch of these that are still pending at the state level. California does remain kind of the big outlier in terms of the other states are more or less becoming similar to each other in a lot of the ways that their laws are being enacted with some individual quirks.
A big exception to note is that, well, there was an exception to California for employee personal information and business to business or business contact type personal information. There were exemptions that expired at the end of last year. So that means there is no exception. If you have employees in California and you're subject to the CCPA, then they have the same rights as consumers or your customers or whatever. Whereas the other states thus far have all exempted specifically in the law. It wasn't an exception to the law, but an actual carved out, doesn't apply to employee personal data. And that it has been sort of a challenge for some of our clients who don't get a lot of, they're B2B mainly, so they don't really get much consumer data, but maybe they have 10,000 employees in California. As if there wasn't already enough employment law in California, this is another layer of a notice and different rights that your California employees have because they let that exemption expire.
So taking a very high level view of these and trying to find some common themes that we could pull out in approximately the next 10 minutes, we have tried to summarize the things that are key things that if you're already GDPR compliant, you should be paying attention to with the US laws.
Yeah, the scope and applicability is an interesting one because especially when we're talking specifically at I think our point of this contrast, Nicole, is like the state comprehensive privacy laws. I mean, we're not getting down to the nitty gritty of all of them, but whereas, when the GDPR came into effect, a lot of American companies that had not had to pay attention to it previously because they weren't somehow in scope because they didn't have operations in Europe came in scope. At this point, the state laws are you doing business in the state? They don't necessarily define what that means, doing business, but it likely doesn't have extraterritorial applicability the way the GDPR could.
Yeah, and you don't run into the same sort of, well, you can run into it in a couple of the states. I was gonna say you don't at all. The marketing and the goods and services prong under the GDPR, more of the states rely on this concept of how many people in the state are you getting data from and what are you doing with that data? Or if you're selling it, then it's a lower threshold number. And if you're not, then it's a higher threshold number typically to become in
A
scope.
number of the states have, it's 100,000 residents of that state, and in some states that's actually quite a lot. California is one of the biggest states, so obviously that's not that many people in California, and they even lowered it to 50, but it is a lot of people in Colorado, and so we do have a lot of clients who they would never have that many people's personal information in that state, so they're not subject to the law even if they are doing business in the state. So it's a state by state analysis on which ones to apply to. Defining personal data. Well, first of all, California decided to call it personal information. Many of the other states went kind of helpfully with personal data. Virginia uses the controller and processor terms that we're familiar with under the GDPR. But it is the same sort of broad anything that could be identify a natural person or be linked to a natural person. I think where the more interesting distinction comes up is in what's considered sensitive personal information or sensitive personal data, as opposed to the special categories. I mean, the list is not exhaustive in California, but there is a lengthy list. It isn't contained to just sort of the categories under the GDPR that are considered special categories. There's a longer list of examples and a longer list of potential applicability. And there are specific obligations under some state laws to either get opt-in consent to collect or use that kind of information, or in California, you have to give certain people the right to opt out of certain uses or disclosures of it, depending on what you're doing with it. So there's a little bit more analysis of what kinds of information you're gathering, whether or not it is considered sensitive, and then what rights apply.
And I think a couple of the sensitive personal data pieces to highlight in the US context are financial data, which is not within that special category. The special category, I guess, category under the GDPR. I'm running out of words here. So financial data will fall into scope within the US. And then California also has some that apply to things like account numbers and the account login information. So your username and password, or your secret codes, that type of information would fall under it. And then this interesting one as well that has to do with the contents of your communications. If the business that is the recipient of them was not the intended recipient, then those contents can also be sensitive personal information. So just some distinctions to pay attention to there. The consents and opt-outs, Melinda mentioned just a bit. In general, the GDPR will rely more heavily on consents than most of the US laws. Most of them rely fairly heavily on opt-outs, with some distinctions around sensitive personal data, which can require an opt-in depending on the state to be able to use that data, as well as the data of children, which can be an opt-in of the parent, or depending on the age of the child, can be an opt-in of the child, sort of
Teenager,
yeah, the teenager, basically. So those
yeah,
are
the US has just much more of an opt-out than an opt-in style regime for almost everything. So the situations where you do have to get consent, and outside of the scope of these, but by the biometric privacy laws I was talking about, like, those are ones where the whole cases are built off the fact that you didn't get this specific opt-in consent prior to collecting this information. We'll see how this plays out with the state laws that have restrictions of that nature, because we haven't really seen it yet being enforced.
And then another issue that shows up in the US that is not really an issue under the GDPR is this whole concept of selling data, sharing data in California, or targeted advertising in all the other states. So selling personal data can mean exactly what you think it means in certain states, where it is literally like, here's data, give me money. In other states, they've taken a much broader approach to what a sale of data might be, and that would be any sort of compensation, or it can even be like a discount, or basically a benefit for the fact that you are giving that data to another party. So sales can be a particularly thorny issue, is one that we deal with a lot, particularly with companies that have been in the GDPR moving into the US market and need to figure out how to deal with that piece of it, because there are opt-outs related to that particular element. Sharing under California law is a particular concept that has to do with cross-context behavioral advertising. All the other states use the term targeted advertising. There are some minor nuances in those definitions that we are not going to get into today, but more or less the same type of thing where you are using data to target or personalize advertising to an individual, and people have the right to opt out of that.
The usual way to conceptualize the difference between these state laws and European privacy, or even privacy laws or data protection laws in any other countries, these are fundamentally consumer protection laws. Yes, California has brought in employees, and yes, it goes a little bit beyond that, but the idea is a consumer protection sort of commercial oriented focus, whereas I would characterize European data protection law is more of a human rights type law. That's why it's umbrella and not specific to different types of data. And that's why this comes up a lot, and why the focus for a lot of our clients who are grappling with complying with US law, where they already are compliant with GDPR, is, okay, so the sale and sharing thing in California sort of comes down to cookies. What cookies and trackers are you using on your website? And do you have to give people the right to opt out of it because it doesn't arguably constitute a sale or a share of the personal information that you're collecting through the site? And that is like a very particular way of approaching it. It ends up at the same place of sometimes needing to have a cookie management tool that allows for opt-outs, but it's coming from a different perspective than the European.
Yeah, and you're managing a different issue. So you're under the GDPR, it's really a necessity or a strict necessity, essential cookie,
We don't have lawful bases in these laws. They decided not to take that concept. So it's a different vibe. And also to Nicole's point about talking about, we're not getting into the definition of sharing and all these little minuscule things. These states have hijacked these words. So like if you use sale wrong, or you just casually say, we'll never sell your personal information. It's like, okay, I get what you're saying. Like you would want your customers to understand that you'll never for money offer their data up for sale. But under California, you might be selling it just because you're using a certain online tracker on your website, right? So you can't as clearly say that. Or we may share your information with blah, blah. Well, share now has a very specific definition under California law. So is that what you meant to say? And it makes drafting privacy notices complicated, in addition to the specifics of, like, say, Swiss law or versus the GDPR, all of the things you have to think about. It's whether or not you are correctly wording what you're saying you're doing, so you're not inadvertently making a disclosure about that could be perceived as a violation of the other law, or a representation that you're doing something that you're not allowed to do. And that flows into notice, I guess.
Yeah, so I went ahead with the notice here. Yeah, I think the other big thing on notice is that, as opposed to what David said with Swiss law, where you can, under Swiss law, write a very simple notice, the US privacy laws have kind of gone the other direction. California in particular, if you look at the regulations, has an extensive list of things that must be in your privacy notices. They're explicit on language and a number of pieces that have to be in there. Everything from language that needs to be there if you're offering financial incentives, to whether or not you're selling or sharing data, what kind, the types of targeted advertising, all the rights that people have, how you go about exercising those rights, and a number of different things that have to be there. So
retention. It is hard for almost any company to actually make an accurate representation about how long they retain and when they destroy a person in the context of an online privacy policy, and they're often going to be wrong, as I said. But and we'll see how far the California AG and other regulators take it. But you are supposed to make representations about that, which we tend to keep kind of high level for that very reason. It's too hard to say exactly what they're going to do, and we don't want to inadvertently represent that the data will only be retained for a shorter period of time than it actually will be retained. But if they try to force companies to be more clear on that, then you're going to come into a real conflict with not wanting to say you're doing something with data that then, if you're not actually doing it, could put you out of compliance with another state's law or EU law or any other country's law.
Or put you in front of the FTC, which
right, exactly, for having misrepresented someone, misled people.
So I'm just going to get to the end of this slide so we can give Joyce plenty of time as well. A couple others just to highlight: the data processing agreements under US law, many of the same obligations as under the GDPR, but also some very specific callouts, in particular under California, which has, instead of the controller processor concept that we are seeing in many of the other state laws, has the third party, contractor, and service provider distinction, all of which could be technically some sort of processor under the GDPR. So each of those has a different set of requirements under a data processing agreement. And then the exceptions to compliance. So if somebody asks you to do something with their data, there are many ways that you can say no in the US. Entire lists of them, but so there are a lot of ways around that one.
Okay, let's end on a high note. Like one difference in the United States, you do not need data transfer agreements because there's no these states can't enact cross-border restrictions and violations of federalism. They can't set foreign policy and say like you can't export the data to another country. So at least you don't have to do standard contractual clauses yet. I mean, we'll see.
You don't have to worry about giving data to a court or law enforcement or anybody else, basically, government level in the US that is asking for it under any of the laws. Quick note on automated decision making. This is an area of US law that's still fairly unsettled. It's showing up in a lot of the privacy laws, but it is not restricted in the same way that we see in the GDPR to solely automated decision making. It seems to have a broader context in the US, but it's still, we're still waiting to see how that's going to.
Yeah, the California Privacy Protection Agency is supposed to tell us exactly what it is and how it's supposed to regulate, and we do not have all the parameters. So maybe they'll go with the European approach to it. Maybe they won't. We don't know yet.
Yeah. So we will hand it over to Joyce. Oh, and our second CLE code. So write this one down. It is accommodation.
Great. Thank you, ladies. So we've been talking a lot about privacy situations, and we're going to switch a little bit to a different overlay with respect to information. And we're going to talk about actually inclusion and providing access to information or to goods and services that businesses offer through their websites. In the US, that is somewhat governed under the Americans with Disabilities Act, and that law has very different titles under it, and we're talking specifically about Title III. Nicole, if you can advance the slide, please. Title III is the part of the ADA that deals with what we call places of public accommodation, which is an actual term of art as defined in the statute. And the ADA prohibits discrimination against individuals with disabilities in all areas of public life, specifically here talking about private places that are open to the public. And it requires that businesses that do qualify as a, quote, place of public accommodation provide equal access to their goods and services. And further goes on to say that the business must provide auxiliary aids and services that are necessary to effectively communicate with individuals that have disabilities, whether they be hearing, vision, mobility impairments, etc. Nicole? So under the statute, as I said, it's a term of art. A place of public accommodation is actually defined. I'm not going to read it, but the statute actually lays out the 12 various categories that you must fall into. And of course, noticeably absent from this is websites. So of course, when the law was enacted in 1990, websites were not an issue, and they have since become obviously commonplace for virtually every business. And they, as I said, are not on this list, but many of the businesses that are on this list open to the public obviously have websites. So the question becomes, next slide, please, is whether the ADA applies to websites. I know that this is somewhat small and difficult to read, but essentially what the first block says, the Department of Justice unequivocally says Title III does apply to websites. They basically say that businesses that are open to the public has to take steps to provide appropriate communication aids and services where necessary to ensure they effectively communicate with individuals with disabilities. And a website with inaccessible features can limit the ability of people with disabilities to access a public accommodations, goods, and services that are available through the website. Of course, that's the Department of Justice's position. The Department of Justice actually enforces the Title III of the ADA, but that is not necessarily the opinion of all the courts. And over the last 5 years or so that we've seen this litigation, the courts have been wrestling and struggling with this issue. There's basically a patchwork across the United States in terms of these decisions. Some places say websites are places of public accommodation. Some places say they are not. And you can have the same business depending on where the business is sued that comes out with a different decision. Some places are saying if a business has a brick and mortar presence and they operate a website, then they fall under the public accommodation. Some places are saying, or some courts are saying, that if they do not have a brick and mortar presence, but they just offer businesses services online, that they're not subject to it. So there is a virtual patchwork, and there is an inability to obviously say what the consistent law right now is across the United States. But assuming for purposes of this conversation that the ADA applies to websites, the real question has become what standards apply. Nicole, next slide. The ADA itself, as I said, because it was passed so early on, doesn't have specific regulations written into the statute or in the accompanying regulations it does have. So what this has done is it's opened the floodgates, and I've just put up some basic statistics about the thousands and thousands of lawsuits that have been filed under the ADA. Here we are in 2023, about a little more than halfway, but at the halfway point, I think there was 4,000 suits that had been filed. Most of them have been filed in, not surprisingly, California, Florida, New York, Texas, and Pennsylvania. And I specifically say California and New York on this list because under the ADA Title III, if an individual sues, they're claiming for access to something specific. So the relief available to them is injunctive relief, i.e. fix the problem, and attorney's fees. But in California and New York, they tack on various state laws, which are giving the ability for the individual, the aggrieved individual, to get damages, which is why we're seeing so many cases filed in those jurisdictions. Interestingly, today, there's oral argument in a case in front of the Supreme Court of the United States called Akeson versus Laffer. And that court is hearing argument today to determine whether a tester, and again, that's a term of art, has standing to sue under Title III, because what these plaintiffs groups are doing, they're not even using individuals who truly want to go to a business's website and buy a good or access a service. They're just logging on and looking for various websites that appear to be non-compliant, and then they sue them and they say, I'm a tester. It's my job to determine whether there is access and compliance, and I'm suing, even though I had no intent of either visiting the brick and mortar location or utilizing the services of that specific business. So the court is hearing oral argument on that today, and obviously that decision will come out this term, and it should drastically affect whether we see cases go down or whether we see a continued increase. I will say, though, even if they say you have to have standing, it's pretty easy for these plaintiffs groups that we've seen across the country to find, one individual who can go to multiple websites and file, dozens upon dozens of suits claiming websites are inaccessible, because it's a pretty easy thing to find out once you log on whether the website's accessible. So next slide, please. Very briefly, basically, when you talk about disabilities that affect internet use, it could be anything, like I said, that has to do with someone's disability, whether it's vision or hearing or mobility or intellectual disabilities. And I've just listed a few of the things that come up as a quote unquote kind of website barrier, whether it's color contrast, the lack of text alternatives, meaning people who are visually impaired, they are not able to see pictures. Obviously, they need to have some sort of a description. If you're having videos or other sound issues on the website, if there's no closed captioning, that's an individual for hearing impaired individuals, as well as if there's individuals with mobility impairments and they can only navigate using a keyboard rather than a mouse. That can also be a problem. And all this comes in terms of programming and software and whatnot on the businesses, in particular websites. Moving on. So as I mentioned, businesses are scratching their heads and they say, okay, well, I may have to be accessible depending what jurisdiction I'm in, but assuming I do, what are the standards or regulations that apply to me? And that's really been the big question over the last several years. And the answer is that there's none. The Department of Justice has on several occasions talked about imposing regulations for Title III and talked about doing notice of proposed rulemakings. And as the administrations change, those things get shelved. And we have not yet seen a notice of proposed rulemaking or specifics with respect to Title III. We do right now have that notice of proposed rulemaking with respect to Title II, which governs accessibility for state and local governments, but that is not obviously for private businesses. So what is a business to do? Because if you say, I want to be compliant with the ADA, that is not a clearly defined term. And essentially what courts and the Department of Justice are doing is they're looking to an organization called the World Wide Web Consortium, or W3C. And this is a private industry group. It's international, where member organizations have basically worked together to develop some web standards. And I put the website up there. There's a lot of information. And this W3C organization has developed what is called the WCAG, the Web Content Accessibility Guidelines. And whether it's courts or the Department of Justice, as I said, they're often looking to these particular standards, even though they're industry standards not adopted by law. They're looking to those standards to determine what is considered to be compliance with the ADA. And these were first issued in 2008, and they've since been revised and updated. And right now we're under the WCAG 2.1. 2.2 is scheduled to come out. And I think there's even a 3.0 and beyond, and I'm sure they'll continue to be upgraded. But the website that is for the W3C gives a tremendous amount of information. I've put the website for the WCAG 2.1 standards at the bottom of this, and I would encourage you to take a look at it. If you turn the page, please, Nicole. The WCAG standards have basically 12 to 13 guidelines organized within 4 principles, whether the information is perceivable, operable, understandable, and robust. And then under each specific guideline, there are testable success criteria. And the success criteria go to level A, AA, and AAA, with AAA being the most strict or the most successful, I would say, in terms of compliance. And the success criteria are what determine conformance to WCAG. So if you meet the success criteria, then you are technically compliant, as that word is used, with the WCAG. The problem that we've seen in a practical context is that many experts disagree as to what is conformance, even within the W3C or the WCAG guidelines, because these are untested concepts. They're not regulations. Some of the things are not well defined, and it continues to be an area where we'll see litigation. Next slide, please. But essentially I've given here, and I'm not going to read it, but it's an overview of the WCAG 2.1 standards. And this just talks about some of the, as I said, those 4 characteristics and some of the things that you should be doing for your website in terms of text alternatives, captions, ability to use, keyboard functions, some of those other functions. And this is all laid out very nicely on the website. And this is what they call the 2.1 at a glance. So there is good information there. Finally, next slide, please. If I was going to say a few key takeaways here, regardless of the fact that there is no defined law or regulations under the ADA, I would say it is highly advisable to modify your website to improve or increase accessibility. There are multi-millions of individuals with disabilities, all types of disabilities, and of course, it's good business practice and good sense. Forget what the law is, right, for a moment, but it's good business practice to have these people be able to access your websites and purchase your goods and use your services. And in terms of what standards you should use, I would encourage you to consider using the WCAG. The Department of Justice also lays out some other alternatives like Section 504, 508 of the Rehab Act and some others, but I think that the WCAG are more commonly used. Another takeaway is to make sure that you have an accessibility on the homepage of your website. This is more just a practical one that I've seen as a result of so much litigation, because there is trolling of the websites by plaintiffs' attorneys. They look for on the homepage an accessibility statement, and at the bottom, when you click on it and hear the terms and conditions, it basically says this website is compliant with WCAG, whether it's 2.0 or whatever, and at a single A, double A criteria, or if you're in the process of it, maybe you state that. There's tons of examples if you just go out and look on the website, but having that accessibility statement many times I find kind of stops the plaintiff's attorneys in their tracks, and they'll move on to the next website. The third kind of takeaway is to hire or utilize someone with proper technical knowledge to make the website improvements. This is not a lawyer. I do not know how to make the technical improvements, but there are a lot of various vendors and consultants that do. We've also had a lot of clients use their internal IT people, some with success and some without. So if you've got sophisticated IT individuals, just, that's fine to use them internally, as long as it's someone who knows and has the proper technical knowledge. Obviously, websites are not static. They're constantly changing. New content is constantly being added. So there should be some sort of process, policy, procedure, whatnot, for as new information is added to the website to ensure that it is in an accessible format. And I often encourage clients to conduct periodic audits, whether they're doing them internally or having a third-party vendor do them, to ensure that the website remains accessible once it's up to certain standards. And the last thing I'll say is that a lot of websites obviously have information that is either posted or controlled by third parties, or is linked to, there's a link to another third party. You can and you should try to encourage whatever third parties you're dealing with to ensure that the content that they are providing is also accessible, as can be done at the contracting stage and whatnot. But it's very important to address at the front end, because a lot of times we've seen clients that are getting sued, but they don't have control to make changes with respect to some of the things that are internal into their websites. So much more to come on this, but it's basically an ounce of prevention here. Get your websites as quote unquote compliant as you can, and hopefully you'll avoid one of these thousands of lawsuits that we've been seeing. And I think that concludes our presentation. I think we're right at
we are 1 minute early. I'm just going to repeat the codes. So the first one was consumer. The second one was accommodation. We do have a couple quick questions. I can see if we can get through them. Somebody had asked if job applicants' personal information was subject to state privacy acts, and the answer is only California at this point.
Well, I actually think it's a little more complicated than that, because if a job applicant is just a California resident, like they don't have an employee relationship with you yet, it's kind of, you might have to investigate.
Yeah, but potentially the others tend to, it tends to get lumped with the other employee exemptions. So, and then we also had a question on what approaches are international companies taking to the US law compliance. Is it state by state, or is it sort of more global? I would say on the whole, most of them are still targeting California because it has the greatest amount of distinctions, especially if you're already GDPR compliant. There's a lot of the language in an existing policy, privacy policy, for instance, that can be sort of nuanced for many of the other states, so that they're more or less covered with some additional language. California is still probably what most people are aiming at, though. And then one final question. Is the ADA relevant for business to consumer only, or would it also affect companies active in the business to business space?
A very important question. Technically, by definition, it would be with respect to the consumers and the individuals that would be purchasing your goods and services, and not from a B2B standpoint. But I imagine that that could be technically covered under some different aspect. And for example, if you've got an employee with a disability that is dealing with another business, and that employee has a disability and they need access or some sort of modification with respect to, you know, even trying to deal with that other business, that's going to be covered under Title I of the ADA in terms of making the employee the appropriate accommodations. But the way that it is written, and again, that's as of now, the law is evolving. This is with respect to places of public accommodation, so they have to be technically open to the public for the goods and services that are available to the public.
All right. Well, thank you everybody for taking the time to join us today. I believe we actually got all the questions that were in the Q&A answered, and yeah,
Feel
thank
free to
you.
reach out to us with additional questions though.
Yeah, you're welcome to reach out. You'll be getting some additional information along with the deck and the recording, and watch for the survey to fill out if you need the CLE credits. And thank you to the Vischer firm for being able to join us today to give us some background on Swiss law as well.
Very thanks also to you, and have a great day.
Thank you, everyone. Thank you.
Yeah.
Bye.
Bye-bye.